Good morning, ladies and gentlemen. I am Ayanda Mazwi, Senior Assistant Ombudsman at the Office of the Ombudsman for Short-Term Insurance. Thank you for taking the time to attend our consumer workshop again this year. We had to resort to this virtual platform in order for us to stay connected. This has now become our new normal. For those joining us for the first time, welcome. Before we begin, I would like to give you a brief overview of our office. The Ombudsman for Short-Term Insurance, abbreviated as OSTI, is an independent, non-profit industry ombud scheme. Short-term insurance includes motor vehicles, buildings, household contents, cell phones, travel, disability, credit protection insurance, as well as commercial insurance for small businesses and sole proprietors. OSTI's mandate is to provide the insuring public and the short-term insurance industry with a free, efficient, and fair dispute resolution mechanism. We do this through an alternative dispute resolution process. OSTI is not a court of law. We examine the information and evidence presented before us by the parties to a dispute. Our office does not, nor is it empowered to procure evidence on a claim or to interview witnesses. Our recommendations to the dispute are guided by the legal position and principles of fairness and equity. It is important to point out that OSTI is independent and impartial. This means that it is neither a consumer champion nor an industry trade body. If after considering the merits to the dispute, we believe that the insurer's decision is not justified or that the insured's issue was unfairly handled by the insurer, we will say so in our recommendation. If, however, we do not find fault on how the insurer dealt with the matter, we will find in favor of the insurer. Now, the aim of our workshop this morning is to briefly outline what consumer behavior or conduct influences the validity of a short-term or non-life insurance policy or claim. It is important to address this issue. When a consumer spends their hard-earned income on insurance, they are effectively buying peace of mind so that if anything happens, they have a certain amount of protection in place. You will see in our annual report on our website that our office analyzes its complaint and outcomes annually, and as such, we have noted that where the insurer fails to comply with his or her obligations under the insurance contract, the insurer may be well within its rights to declare a policy or a claim invalid. Most of these grounds can easily be avoided. Being at the receiving end of an invalidated insurance policy or claim can be surprisingly easy where the consumer does not understand the operating provisions of the policy and what their obligations are. I'd like to welcome our panel of speakers this morning, Darpana Harkison, Thasnim Dawood, and Peter Nkhuna, all of whom hold a senior assistant ombudsman position in our office. We also have our CEO, Edith, present with us, and she will engage with you more during our question and answer session. Despite conducting this workshop under a virtual platform, we want this to be an interactive session. So if you look at the right-hand side of your screen, you will see our live event Q&A chat box. Please type in your questions and comments there. We will have a Q&A section after the end of the presentations. However, please feel free to leave your questions or comments during the course of any of the 3 presentations. I will now dive right in and introduce you to our first panel speaker, Darpana. She will broadly touch on misrepresentation and non-disclosure at sales stage, during the operation of the policy, and at claim stage. Over to you, Darpana.
Good morning, ladies and gentlemen, and thank you very much for joining us on this rather chilly spring morning. My topic of discussion this morning is misrepresentation or non-disclosure at sales and claim stage. One of the most important consumer behaviors or conduct which influences the validity of a short-term or non-life insurance policy or claim is not telling the truth. In other words, consumers either provide incorrect information, also known as misrepresentation, fail to provide relevant information, or refuse to provide information, also known as non-disclosure. Consumers must always bear in mind that an insurance contract is a contract of good faith, which means that at all times both parties must act honestly without any malice or the desire to defraud the other party. When concluding an insurance contract, insurers rely on information provided by the consumer at sales stage in order to first ascertain whether they wish to accept the policy, and secondly, if they agree to accept the policy, then on what terms and conditions. Therefore, in order for consumers to avoid the pitfalls of providing incorrect information to the insurer at sales stage, it is vital that they firstly listen carefully to the questions which are posed to them, ensure that they understand the question being asked, answer the questions as accurately as possible, and if they are unsure or unaware of the correct answer, advise the insurer accordingly. When OSTI deals with complaints pertaining to misrepresentation at sales stage, we start off by listening to the sales conversation. We listen to the manner in which the question is asked. This particular issue was dealt with in the matter of Mahadeo versus Dial Direct Insurance Limited, where the insurer rejected the claim on the basis of the non-disclosure of a pothole incident, which the insurer argued had not been disclosed, and had it been disclosed, the consumer would not have qualified for a 6-year no-claim bonus and a higher premium would have been charged. With regard to the consumer's previous claims history, the insurer asked the following questions during the sales conversation. The advisor said, "Okay, and accidents or stolen car claims?" Mr. Mahadeo responded, "No." The next question asked by the advisor, "Okay, and claims in the last 2 years at all?" Mr. Mahadeo responded, "No." According to Mr. Mahadeo, he did not consider the pothole incident as an accident. The court found that the insurer did not prove that the pothole incident took place 2 years prior to inception of the policy, and that the consumer's explanation that both questions only related to accident and theft claims was reasonable. The court held that the insurer did not create a duty of disclosure on the part of the consumer, as a reasonable person, based on the questions asked, would not consider that the pothole incident needed to be disclosed. Therefore, the consumer's claim was upheld. Besides showing that a duty of disclosure was created, the insurer must also show that the misrepresentation was material to its acceptance of the policy. Section 53 of the Short-Term Insurance Act provides that the insurer may only reject the claim or void the policy if the misrepresentation is material. That is, had the consumer provided the correct information to the insurer, either the insurer would not have accepted the risk, or that it would have underwritten the risk on different terms and conditions. Therefore, the fact that the consumer had misrepresented or failed to disclose, say for example, the color of his eyes, is not sufficient for the insurer to reject the claim or void the policy. The insurer must show that the color of the consumer's eyes would have resulted in the insurer not accepting the risk and or charging a higher premium. Within the South African context, language barriers, especially in the case of first-time insurance consumers, does lead to confusion and misunderstanding on the part of the consumer. Consumers must ensure that they fully understand concepts such as claims, losses, comprehensive insurance, regular driver, principal driver, nominated driver, to name but a few, which are commonly used at sales stage. In insurance, these terms denote certain meanings. However, to the layperson, these terms are not self-explanatory. The consequences of a material misrepresentation or non-disclosure by a consumer at sales stage is that his or her policy may be cancelled with effect from the start date, and the consumer is entitled to receive a refund of all the premiums. However, a refund of a premium will not help when the consumer is dealing with his vehicle which has been written off or his home burgled. The insurer's voidance of the policy in the event of a misrepresentation or non-disclosure also impacts the consumer's insurance experience going forward, as the consumer would have to disclose the voidance to future insurers in order for them to correctly underwrite the risk and charge the correct premium. At claim stage, OSTI often deals with consumers who refuse to provide information to insurers, as they are under the misconception that by requesting this information, the insurer is infringing on their right to privacy. It must be pointed out that all the rights enshrined in the Bill of Rights are subject to limitations, especially in circumstances where consumers have agreed to be bound by the terms and conditions of the policy contract, which provides that the consumer must comply with the insurer's reasonable requests. Consumers are required to be entirely truthful about the circumstances prompting a claim submitted to the insurer for payment. The insurer needs to establish the facts surrounding the loss so as to determine its liability in terms of the policy. The insurer can reject a claim where the consumer's version with regard to the circumstances of the loss changes at any stage during the validation of the claim, provided that this information is material to the cover provided by the insurer. For example, where the consumer lied about being with his wife as opposed to his girlfriend immediately prior to the accident will not be considered to be material to the claim for damages to his vehicle arising from an accident. However, if the consumer lied about being in church as opposed to being in a pub prior to the accident, this misrepresentation would be considered to be material if the insurer has evidence that the consumer was under the influence of alcohol, as the policy specifically excludes cover where the consumer drove the vehicle whilst under the influence of alcohol. My parting message to consumers is, the truth doesn't cost anything, but a lie could cost you everything. Thank you, everybody.
Thank you, Darpana. That was a very important parting message. I will now hand you over to Thasnim, and she will address you on the importance of evaluating and reassessing your risk, including changes in insurance risks under this lockdown period. Thank you, Thasnim.
Good morning. At OSTI, we often come across complaints where the insured is not happy with the outcome of a claim, where, for example, the offer made by the insurer does not adequately represent the value of the items claimed for, that it was found that the insured was underinsured at the time of the loss, or that the item claimed for was not placed on cover. In many cases, it's because of reasons such as not having reassessed the value of your risk item, for example, the value of household contents, the value of a vehicle, or the value of the building. The failure to reassess or evaluate your risk on a regular basis may have significant financial consequences. It's important to discuss with your broker or insurer and make the adjustments to either benefit from reduced premiums or receive the correct cover and indemnification at the time of a claim. Elements and circumstances of the risk change throughout one's life. Depending on the stage in your life and circumstances, there are times when you might need to add more onto cover, get cover that you never had before, or decrease the cover as per your needs. Without adequate cover, you could risk the loss of or damage to your assets or items, with there being significant financial impact. It's necessary to rationally consider and reassess your cover at regular intervals, for example, once a year, or on the happening of a lifestyle change or adjustment to your circumstances. Depending on the stage in your life and circumstances, there are times when you might want to get more cover or reduce your cover. Whatever your decision, make sure that it is made reasonably, considering your needs and requirements for necessary cover. These conversations could be had with your broker and/or insurer and can start, for example, by looking at the depreciation of your vehicle. That's the depreciation value of your vehicle, to adjust premiums being paid. If you have acquired valuable items which form part of your household contents, these should also be on your policy and would probably need to be specified to ensure proper cover. Currently, we find ourselves in a very unfortunate and unusual circumstance, namely the COVID-19 lockdown, which forces many people to relook at their cover. During this time, circumstances would have changed for many people. For example, many would have started working from home, become unemployed, had a change in the use of your motor vehicle, a change in the use of domestic premises, and the use of business premises. These would yield changes in your risk, and it's important to inform your insurer of this change in risk, most importantly to ensure that there's proper cover in place and that there is compliance with the policy terms and conditions in light of the change of circumstances in the risk. Informing your insurer of these risks might also yield benefits. For example, if you are working from home and your vehicle is now parked at home during the day as opposed to at your office building, the risk might be different to the insurer and it might need to be underwritten under different terms and conditions. It might also be that your vehicle is no longer on the road as much as before the lockdown, and the premiums may change for the risk profile of your vehicle at this stage. While the vehicle is not on the road and driving less kilometers in a month, there are some insurers that will provide cover where the premiums are calculated based on the number of kilometers driven in a month, and this change could result in a reduced premium and a financial saving. If one is unemployed, one should check if you have cover in place for income protection. If your domestic premises are now being used for work and your electronic equipment and other work equipment is now placed at your home, your insurer should be advised so as to allow the insurer to underwrite the risk accordingly. If your business premises are now no longer being used for business, it's important to find out what terms and conditions are in place in relation to an unoccupied premises and what obligations you have as the insured under the new risk. The need to assess and reevaluate your circumstances and your risk is not only important and beneficial during the lockdown to inform your insurer of, but it's necessary at any stage of your policy. Changes in your risk must be communicated to your insurer. Having said that, ultimately, it's important to ensure that you have the right cover for your valuable assets and items in order to ensure that there's no disappointment at the time of claiming. Thank you for listening.
Thank you, Thasnim. And just a quick reminder that we will be having a Q&A session after the last presentation, which I will introduce to you now, which is Peter, who will talk about conduct issues on the part of the insured. Please start drafting your questions and comments so that we can have an engaging session after this last presentation. Thank you, and over to you, Peter.
Good morning to one and all. As per the introductory remarks by Ayanda, I'm going to speak about practical ways in which one can ensure that one gets to enjoy the benefits provided in terms of their policy. I'll start off with the earlier part of the discussion where Darpana was telling us about how to make accurate and truthful disclosures to the insurer at sale stage. And now you have made those disclosures, your policy is now in place. A lot of times, especially when you conduct your business over the phone with the insurer, they will tell you immediately that you will be receiving your policy documents. It is very important that once you receive your policy documents, you go through them. Firstly, to check for any inaccuracies that have been captured on your policy schedule. And secondly, to make sure that you understand the terms and conditions of cover so that you can comply and make sure that you do not compromise yourself. Very important to note that you cannot comply if you do not know your obligations in terms of the policy. Sometimes it does happen that you do not receive your policy documents, and in that instance, it then becomes your own responsibility to make sure that you contact the insurer or the broker if the documents were supposed to be forwarded to you by the broker, to let them know that you have not received your policy documents and that they should please provide you with copies. One of the most other important conduct issues on the part of the insurer, or sorry, on the part of the insured, is to make sure that you pay your premiums. If you do not pay your premiums, you cannot enjoy cover. Make sure that your premiums are paid timeously all the time. Luckily enough for us consumers, we have got the policyholder protection rules that provide that insurers must allow us 15 days grace period in instances where we are unable to meet the agreed premium payment dates, so that we can raise the funds or correct whatever issues we may have experienced so that we can catch up with our premiums. Some insurers will have better terms in that regard, in that some of them will say if you missed your premium the first occasion, instead of giving you the 15 days, at the next collection point, which is the following month, they would then do a double debit to make sure that you have continued cover throughout the period. So please make use of those grace periods that are allowed. And if you have any doubts, please speak to your own insurance company to find the specific terms that would apply in your instance. Thasnim has also mentioned that with the changes that happen due to COVID, we need to update our insurers with any changes that may have taken place. This is something that happens throughout, not only as a result of COVID. And some of those things would be things like perhaps you have bought an additional expensive watch, you've bought additional furniture, which means that your sum insured needs to be adjusted upwards. You may have also in certain instances lost certain things that you did not necessarily claim for, and perhaps those could have also lowered your sum insured somewhat. So it is just important to make sure that you convey all of those changes to the insurer. You also need to make sure that you safeguard and maintain the insured property. Take care of the property as if it were not insured. For example, in cases of your motor vehicle, make sure that it is serviced. In case of your house, for example, make sure that the roof is sealed and waterproofed. If you need to have a new coat of paint, make sure that that is done. Some of the more common examples are in motor insurance, for example, making sure that you have a tracking or telematics device installed in the vehicle if it is a security requirement. In the case of your home, you may find that the insurer requires that you install an alarm system, or that there should be burglar bars or security gates installed. Very important that you comply with those requirements. Do not allow people to drive your vehicle whilst they are under the influence of alcohol, and do not do that yourself. Do not allow unlicensed people to drive your car, and generally comply with the law. A lot of policies currently require that there must be compliance with the law. Otherwise, the insured may find themselves compromised in terms of the cover enjoyed in their policy. And I think I leave it at that. Most of the other more specific things we'll discuss in the panel discussion that is about to follow. And I thank you for your time.
Thank you, Peter, and thank you to all the speakers. We have some questions and comments on the chat session. We may not be able to address all of them, but we will endeavour to touch on as much as possible within the remaining time. One recurring question that I have seen concerns consumers, and I'd like to address this with you, Edith, is how has the COVID-19 lockdown affected the operations of your office?
Thank you, Ayanda. So luckily for us, we have been operating in pretty much the same way as we did prior to COVID-19 and the lockdown. In fact, we have year-to-date received slightly more last year and to service those complaints. Our ports of entry, which currently exist, continue to be available to consumers and insurers. Our telephone lines are available, fax, email, our website, and even with walk-in complainants, if they do happen to go into our office, we've set up a procedure whereby we will obtain those details and we will call the complainants and try and assist them telephonically. Thank you, Ayanda.
Thank you, Edith. I will address the next question to you, Darpana, as you spoke about misrepresentation and disclosure. Sally would like to know if her constitutional rights to privacy are not protected under the short-term insurance policy.
Her constitutional rights to privacy will be protected to the extent that she has given the insurer permission to protect those rights. But when it comes to the investigation of a claim, so when the insurer is requesting information, specifically, I can think about information with regard to the insured's whereabouts. So to validate what the insured has advised the insurer, the insurer would request, for instance, the beacons and billings information. So any information that is contained in there would then be made available to the insurer, and that would not be considered to be a breach of privacy. But in terms of other personal information which the insured has provided to the insurer, say for instance, during the sales conversation, where the insured provides the insurer with her ID number, with her physical address, that kind of information is protected.
Thank you, Darpana. We have two questions which I think are linked and would also apply to your topic of discussion. The first one states, how much information should I share with an insurance company? And then we have a second question from, I just want to get that one, from Nele Kutia, which says, do you have an obligation to disclose information which was not specifically asked during the sales stage? For example, if the insurer didn't ask me about a previous conviction for DUI, whether I have any charges for reckless and negligent driving or fraud. So if that question is not asked specifically, do I have an obligation to disclose that information?
Ayanda, I'm going to answer both questions together. So, broadly speaking, when it comes to providing information to your insurance company, the saying that goes, less is more, definitely does not apply here. You should provide as much information as possible. I'll deal first with the sales conversation. During the sales conversation, obviously the insurer has created a duty of disclosure by asking certain questions. And obviously the questions that have not been posed, our view has been that if the question was not posed to the insured, then no duty of disclosure was created. And in line with the Mahadeo versus Dial Direct matter, even the questions that have been asked are subject to scrutiny. However, there is the common law which provides that certain information is considered in the common law to be material and therefore must be disclosed to the insurer. An example that I can think of off the top of my head is where you are running a woodworking factory and you are now applying for insurance to the, you are now applying for cover. You disclose to the insurer that that you are, okay, maybe that's a bad example, but okay, so basically at inception of the policy, you are initially building, making something out of plastic, or no, that's not a good example either. Okay, but during the course of the policy, say for instance, the you now start manufacturing furniture out of wood, and that in itself would change the risk completely, because it is a fire risk. And assuming 5 years down the line, the factory catches a light and the insurer says, but you didn't tell us that, you know, that you were now manufacturing furniture out of wood, which posed a higher fire risk, and therefore we were not in a position to correctly underwrite the risk. With regard to, so that's what I'm saying, with regard to the question of how much information must be disclosed, disclose as much information as possible. I can think of another example when you're involved in an accident. I mean, even though the insurer might not have asked you whether the police were at the scene of the accident and, you know, whether you were breathalyzed, that is something that must be disclosed to the insurer. Yeah, thank you. I hope I've answered your question.
Thank you, Darpana. I think we can also add that in terms of common law and the Short-Term Insurance Act, you have an obligation to disclose information which you know personally and believe that it may materially affect the insurer's assessment of the risk. So I think the message here should be that you disclose the information that you know personally would affect the assessment of the risk, and then leave it to the insurer to determine in terms of its underwriting guidelines whether that information is a material to it, and this will actually prevent any unfortunate circumstances at claim stage. Our next question is from Laken. Peter, I'll pass this question over to you. Laken would like to know, is there a provision for for payment holidays during the pandemic?
Thank you, Laken. Before I answer the question, I just wanted to also add on the earlier question to just add the statement that when in doubt, rather disclose. So going to the question of potential relief during COVID times, there are various ways that one can get the insurer to provide some sort of relief. My first advice would be to make direct contact with your insurance company, find out what it is that they have in place for such circumstances, and make the relevant arrangements. One of the things that could be done is to downgrade your cover. For example, let's say we are in Gauteng and it is in winter. The risk of hail is very low, and you may find that it is possible to take out hail cover from your policy and reduce your premiums in that regard. That could be something for you to explore. But it is very important that in the process of doing that, you do not water down your cover too much to the extent that you are left exposed. So be very careful as to how much you trim if you are trimming. And in fact, I would suggest rather that before you start considering to trim your cover, explore alternative ways first, and then only as a last resort do that. And a last word on that, remember also, if you have trimmed down on your cover under the current circumstances, when things move a little bit closer to the normal situations, go back to your insurer, update back to the original conditions so that your cover is not compromised in that regard. And I thank you.
Thank you, Peter. I think the very common question or the very common point here is that of contacting your insurer and remaining in constant communication with your insurer or your broker and updating them of the changes in your circumstances. Edith, I've got a very interesting questions from Mabula. It states, as have already stated in the presentation, consumers need to adhere to the law of the country at all times. One of the cropping issues is whether a consumer will be covered if an accident occurs after the legislated curfew.
That would obviously the way in which actually drafted, and often what is required is that there is a link between breaking the law and the loss itself, and if the insurer can establish that causal link, then we may need to up that rejection. Ordinarily, that is quite tough for an insurer to do. Insurers are not custodians of the law, especially not the criminal law. We'll look and scrutinize it very carefully before we decide in favor of the rejection of that claim. Thank you, Ayanda.
Thank you, Edith. Thasnim, I have a question from Maya. It states, what is the position of shared responsibility? For example, I have seen claims where an insurer has not paid out the other driver in full because they believe the other driver could have prevented the accident. This seems common if the other driver, who was not at fault, was uninsured.
Hi, Ayanda. Maya, thank you for that question. It's a very interesting one. Normally at our office, well, just to place you in perspective, this actually deals with the issue of delict, and it deals with the issue of third-party claims. So it's between one insured and the other driver, or vice versa. And as I said, it deals with the issue of delict and it deals with the issue of fault. So when an insurer is considering if there are two drivers involved, which one is at fault, that's how the proportion of blame is placed, and that's how payment will then be made. I can't quite answer whether it happens commonly if one driver is uninsured. It might be the case by default that one of the drivers is uninsured, but ultimately what it means is that there's an issue of the principle of blame, delict, and fault, and that's how that ultimately comes out when an insurer is deciding how payment is made when two drivers are involved in an accident. I hope that answers your question adequately. Thanks, Ayanda.
I hope so too, but while I still have you with us, Thasnim, maybe we can also talk a little bit about proportional settlement on the issue of misrepresentation or material changes in the risk during the operation of your policy. Can you maybe explain on that, since Maya wanted to discuss a little bit more around proportional settlements?
So, thanks, Ayanda. In terms of misrepresentation that you mentioned as an example and proportionality settlements, normally at OSTI, that kind of settlement comes out from our equity jurisdiction when, for example, an insurer will say, we have actually suffered a premium prejudice by the incorrect information that was provided to us, and on that basis, for example, if we had known the correct information, we would have underwrote the policy differently, which would have yielded a different premium, and we've suffered 35% prejudice on our premium. We would examine the facts of the case and the merits of the matter surrounding this issue, and we would then say to the insurer to consider paying the claim on a proportional basis, taking into account the premium prejudice that they've suffered.
Thank you, Thasnim. Peter, I'd like you to address this particular question. It says, I'm currently unemployed. What steps should I take to make sure that I received the same benefits and my insurance cover is not interrupted? I think you touched on that on the previous question. But this particular writer is stating that they're unemployed, so maybe there's a little bit more information that you can provide in this regard.
Thank you, Ayanda. I think it's a bit difficult to deal with that situation because ultimately, as we stated earlier on, premiums need to be paid. And therefore, it will probably be a question of whether or not you are still able to make some sort of contribution, how much that is, what kind of cover it will be able to buy for you. And then on the opposite end, you may find that you're not able to make any contribution whatsoever, and that might ultimately mean that your cover eventually lapses, and should you suffer any losses, you wouldn't be able to claim. So once again, I think the easiest thing to deal with in that context and other related contexts would be to have discussions with your insurance company or your broker, explore ways how you can make sure that you ultimately retain cover to the maximum that you can possibly afford. While you are at that, I also wanted to add a little bit on Maya's earlier question. Just wanted to highlight that as OSTI, we do not deal with disputes regarding a liability between parties. Third-party liability disputes do not form part of our jurisdiction. So we wouldn't ordinarily deal with the situation that Maya was referring to. But I also wanted to mention that there is an act called the Apportionment of Damages Act, which informs part of the attitude that you would get when you are claiming between the insured and the third party that is considered to be liable, and vice versa, where it is generally argued that no accident will happen if both parties are vigilant sufficiently. So in other words, even though the one party could be extremely negligent in their conduct, if the second party is vigilant, they will probably see what is happening soon enough to be able to react and still avoid a collision, for example. And a lot of times it's found that the less negligent party could have still done something to avoid a collision, and that is why there would be some sort of apportionment of blameworthiness, and therefore also in terms of what is recoverable between the parties would be affected in that regard. Thank you.
Thank you, Peter, and thank you for elaborating further on that question. Edith, I'm going to combine two questions. The one is a comment from Angelique that states regarding disclosure. When in doubt, is there such a thing as lying by omission? The second one is that, oh, I've lost that question. It was from Philip, which states, shouldn't insurance companies discuss all their exclusions when you take out the policy? And shouldn't they ask you all the questions that they need in terms of their underwriting guidelines before you take out the policy?
Thank you, Ayanda. So with regards to Angelique's comment, the flip side of a misrepresentation is a non-disclosure. A misrepresentation is a positive act, whereas a non-disclosure is a negative act. And I think your comment relates very much to that and those two concepts. And with regards to Philip's question, you know, you can take out a policy in various ways. The traditional way was who would sit down with you, do a needs analysis, work out exactly what cover you were looking for, would do a comparison of the products on the market together with the premiums, and would go through all the questions that those insurers would be asking you, and you would then have to reflect on the questions and provide the answers in writing. And that's quite a long, laborious process. But with the advent of the telesales conversation, insurers don't have the time to go through every single question, to go through they have a limited number of questions that they will ask you. They will hopefully canvass the more pertinent questions, the more important questions that go to the root of the contract, whether they will accept the risk or you on risk based on the answers you give, and where they determine the premium. But they cannot go through every single term and condition. And in fact, in terms of the law governing these policies, which are called the policyholder protection rules, they don't have to go through every single term and condition, especially if these are common terms found in the majority of the policies in the market. They do, however, need to go through those that are unusual, that are special, and those they need to bring to your attention. If they had to go through the entire policy document, a conversation would take a couple of hours as opposed to wrapping up a sale in the matter of an hour or under an hour. Thank you, Ayanda.
Thank you, Edith. That was very insightful. Darpana, Violet would like to know, how does OSTI assess dual insurance? For example, when a complainant only learns at claim stage that cover with a previous insurer was never cancelled.
When it comes to dual insurance, and the insured only becomes aware at claim stage, the only remedy that the insured actually has against whichever insurer was not cancelled is that they would be entitled to a 50% refund of the premiums, but then it would still be subject to prescription as well. So basically, if you're sitting with two insurance policies for a period exceeding 3 years, you would only be entitled to a 50% refund of the premium for a period of 3 years because of prescription, basically. When it comes to claims, it's a lot more complicated than that, because the insured can actually submit the same claim against both insurers. But similarly, both insurers' liability would then be limited to 50% of the claim. It can become a lot more complicated than that, but these are basically the broad principles.
Thank you, Darpana. And whilst I still have you, Ashley, and I think this refers more to your presentation, how would the insurer establish the true facts around a case? So how would the insurer establish that information I disclosed during underwriting was in fact not true? Are they not going to take my word for it?
The information that you provide at sales stage is actually validated only at claim stage, which means that if for instance, at sales stage, you told the insurer that you had not submitted any accident claims in the last 3 years. At claim stage, the insurer would then ask you, okay, who were your previous insurers? They would then approach your previous insurers and ask them for a list of claims that were submitted. And that is how they would go about validating the information, specifically with regard to your previous insurance history, your previous claims history, your previous loss history.
Thank you, Darpana. Thasnim, you discussed a little bit about the lockdown period and the influences of the changes in your risk. Wilson would like an expansion on this issue of the changes in risks during the lockdown period. What scenarios have come through during the lockdown period? So I, for example, can think of working from home. Your situation would change in that regard. if you start to use your home premises for certain business practices, the insurer would like to know, or the insurer would be entitled to know of those material changes in the risk. What other issues have come to light during the lockdown period, in your view?
Thank you, Ayanda, and thank you, Wilson. Yes, Ayanda, those are some of the examples that I mentioned earlier in my presentation. Also, the issue of unemployment or use of your business premises, and particularly changes in general that you've had, like with the use of your motor vehicle or the use of your home premises. And the fact that, for example, and this might actually be a benefit to some people, where, for example, during the day, your home is actually left unoccupied and you're out to work and nobody's home during the day, which raises the risk, for example, of burglaries and thefts. And now during lockdown, you're actually at home the whole day and you're working from home, and the risk of burglary and theft is reduced. And perhaps you can have that conversation with your insurer to say, is there a change? If there's a change in this risk, which is actually probably better for you, what does it do for my premiums? And that might yield a positive benefit for you from, you know, that kind of change in your circumstances. And yes, those are the ones that are generally that I can think of right now, and the more common ones that have you know, caused common changes in people's lives during this COVID-19.
Yes, I'm also aware that some consumers prior to the lockdown period chose to travel home and rather work from home. And by home, I mean their homelands. So if you've moved from, say, Johannesburg to Durban whilst working from home, and your vehicle is now parked in Durban as opposed to Johannesburg, for example, those would be the typical types of situations that would need to be updated, in my opinion. Moving on, Peter, Shannon would like to know, is it important to have an expert evaluate the value of my risk, or is it okay if I just guess the value?
Thank you for the question, Shannon. I think it depends on your specific circumstances. No two individuals would be in the same situation, and therefore what might apply for the one might not necessarily apply to the other. For example, if you have a fairly simplistic lifestyle, nothing fancy, and you are fairly well informed, it might be possible for you to make a personal assessment of what you have in your possession and guess perhaps there's some insured to state to your insurer over which to have cover. Alternatively, if you are somebody that has a lot of very specific, perhaps upmarket luxury things that may need special skills, like artwork, for example. Not everybody would be able to give value on artwork, and perhaps in that instance you might need somebody that has the desired or required expertise to tell you what would be the value of your artwork. So yeah, it really depends, but it is generally better advised of you to do it where there is somebody that is more knowledgeable than yourself conducting the risk assessment and evaluation of your goods to determine the correct sum insured. And a lot of insurance companies as well as brokerage firms do provide services in that regard, where if you insist that you'd like for somebody to come and attend at your either business or home premises, do an evaluation of what property you have and the value thereof, so that you are more safe than not, you can insist that that should be done. Thank you.
Thank you, Peter. In the interest of time, I'd like to suggest that we take one last question. We are just over a minute over the scheduled time, and I'm cognizant of the fact that our delegates have other commitments scheduled. I'd like to ask this last question to you, Edith. Do you feel, or do you get the sense that insurers are acting fairly to consumers during the lockdown period and taking into account the challenges that consumers have had to face during this period?
Thank you, Ayanda. I think it's a little premature to judge insurers at this stage. We have received complaints related to the COVID-19 and the lockdowns, but it's early days. You know, a lot depends on each matter. We need to look at the policy terms and conditions. These are not generic. They can be very specific to an insurer, and also the circumstances of the particular claim. So to pronounce now whether insurers have been fair or not would be unfair to the industry. Also unfair to judge everyone according to the same, or to judge everyone and place them all in the same bucket, basically. We will have to await you know, further developments. These matters are still new in our office. Some have been finalized, but the majority of these matters are still pending finalization and adjudication. I think insurers have continued to behave more or less the same as they have in the past. The only trends is the types of complaints coming into our office that are slightly to the previous year, and that's due to the lockdown and to COVID-19. Thank you, Ayanda.
Thank you, Edith. Now, having laid the foundation on this topic, we invite you to write to us directly should you wish to further interact with our office on the topics we have dealt with or any other issues concerning short-term insurance. Today, we highlighted the importance of consumer understanding the obligations placed on them in terms of the insurance contract. It is also important to be open and frank with your insurer, as well as to communicate with your insurer on issues which you find unclear. You have been a great audience, and I thank you for participation. Before I hand you over to Edith in closing, I would like to just say we appreciate your availability attending this workshop and look forward to having you join us again in the new year. In the meantime, please stay connected with us on our social media platforms and on our website. Look out for our press releases and newsletters as we share quite a lot of information on developing trends in the industry. Please also note that we have recorded this workshop and it will be made available to you on our website, social media, and on your email if we have you on our mailing list. In closing, I will now hand you over to Edith to say a few words before we part ways. From my side, thank you and goodbye.
Just a few words of thanks. Thank you to the seniors and especially to Ayanda for putting this workshop together. Thank you to our event producers, Marilise and Ardila from our office. Thank you for attending this workshop, and thank you to the media for your ongoing engagement with our office. It is much appreciated. As mentioned earlier, we have in fact this year received slightly more complaints than last year. We're very grateful that we are continuing to receive complaints and that we're in a position to service these complaints. Surprisingly, only about 7% of all the complaints received so far relate to COVID-19 and the lockdown, predominantly, as I've said, with regards to business interruption cover and travel insurance. I thank you once again and enjoy the rest of your day.